So, dear friends, today in this part of our discussion with regard to the recently amended liquidation process regulations, here valuation of the assets or the business intended to be sold, this is governed by regulation 35. So, what is this valuation of assets? That is, it implies that individual assets and business intended to be sold. So, the business is different. That valuation of the business could be on the basis of the ability of the business to generate revenues, and that includes goodwill can be valued independently like any other asset when you say valuation of the assets. So, the intention is very clear. It is you can always value the entity as a whole. Individually, plant and machinery, resale value. In a liquidation process, this particular word is used because there is a regulation 32E is there, which aims at keeping the entity as a going concern. If you see the scheme of things, the object of the IBC code is well defined, that revival or resolution. If you see the judgment of Honorable Supreme Court in Innovative Industries, they said that in the preamble itself the word liquidation was not used. In the preamble there was no word called liquidation itself. So, therefore, the emphasis of the entire code is resolution, revival. So, the point is, the point we have to understand that if you see the act is cut into separately. When you say CIR process, that is one, whose main objective is to revival only, and a corporate insolvency resolution process, that is the objective. So, entire drafting of the law, the role of resolution professional, committee of creditors in decision making, exercising their commercial wisdom, everything is defined to achieve that objectives. But nevertheless, what happened, if you see the practical situation, 97% of the entities went into liquidation. So, therefore, for a very long time that resolution process was going on, 330 days, though it is listed as 11 months, and you can see that the time taken by the entities is years together because of the judicial delays. That's whatever it is, there is a delay. The time bound is not at all being achieved. There is that is beyond the scope of IBBI, Insolvency Bankruptcy Board of India. It is not within their scope. That should be done by MCA, Ministry of Corporate Affairs, which is the regulator. So, whatever this IBBI keeps passing rules to achieve that objective cannot be achieved unless MCA takes care. For example, I will give you, they themselves have written in the discussion paper, Section 230 has become a failure, compromise arrangement, and now they don't want to leave it. 30 days they brought it. It has put it as 90 days, compromise arrangement. The Honorable Supreme Court very clearly said in Arun Kumar Jagatram's case, they said the Section 230 is an invention of the NCLAT. When the chairperson was there, he said when you are going for liquidation, you have to first explore the possibility of Section 230 of Companies Act 2013. So, the Honorable Supreme Court was not pleased. Nobody challenged that. Why do you bring 230 into this? This Companies Act is different from Insolvency and Bankruptcy Code, which is a clear-cut code. There what happened, the Honorable Supreme Court very clearly said, you have CIRP, there are provisions in the Act supported by the regulations to implement the said provisions. That is one. When you say this is code, If it is a CIR process, you must apply only that regulations, only that provisions. You can't come out and then talk about, you cannot talk stakeholders consultation committee when you are dealing with resolution process. So again they said, you have a liquidation, there are provisions for achieving the objective of liquidation, again time bound resolution, maximum realization, and there is a provision for revival of the company under regulation 32E. So where will you fit this 230, section 230? Section 230 was invention of NCLAT. They said you don't do all these things. The adjudicating authorities are the reason for the delay of this entire process. That is what Honorable Supreme Court has said. Then finally regulation 2B was introduced and they said time bound 90 days. 90 days. If you see that nothing ever happened, one more legislation means one more litigation, unending litigation. Even in my experience, friends, it was to be completed in 90 days and it was on the verge of completion. The government bank filed a case which resulted in now 900 days delay. So that point is not answered by IBBI. It is beyond their control. If suppose others in the ecosystem, one is the resolution professional that is governed by IBBI. The second one is NCLT that is governed by MCA. There is no monitoring and all. Therefore, the huge delays, they don't have judges. These points resulted in complete breakdown of this process, and even Honorable Supreme Court expressed their displeasure many number of times. But nothing is happening. Here, you must see in light of those points, how this company, many misconceptions are there. Even in the case, the adjudicating authorities are passing the orders on certain belief which is applicable to CIR process. It doesn't apply to liquidation process, much less to section 230. You can't assume everything. This is a code. Recently, that was tested 27, and whether a resolution profession can be removed just like that by voting of 66% by the committee of creditors. Should he not be given some opportunity of being heard? Because he is working. You see, whenever such situation arises, it is dangerous situation, because when you are appointed as the RP, you know, if the bankers doesn't like you, they can remove you. They need not give any reasons. So what is the security for you when you start itself? You know, anytime they can remove you. So either you listen to that bankers and do whatever it is. And you know, the experience shows bankers have no liability. You see, the problem is not recognized by Honorable Supreme Court when they said commercial wisdom is not justiciable. Bankers are first of all not competent to decide, but then there is no other thing for Honorable Supreme Court. In the best of the things available, you understand, in the blind people, when you have a person with one eye is a better person. That situation only is prevailing now when you are adjudicating on the economic legislations. So we are trying to, there is one petition is pending. I am trying to say economic legislation will pass through 3 different stages. The first stage is you are exploring the possibility. The government or executive or the legislature want to give a try. So bring in IBC code, fine. That you cannot, court cannot look into that because they are not experts. That is the stand. If you take IBC, you know, they say everything, it comes under BLRC report we have published and all. Okay, BLRC report based on research and all. You must know, dear friends, what is the object of IBC, because it is creditors in control. It has come from the debtors. You understand, earlier the debtor, the corporate management is still under control. Banks were fighting, SARFAESI and all taking possession. Now they thought that it's better take out that and give it to the creditors in control. Because of that real problem that is being faced, because of the possession in the hands of the management, and the management got displaced, that is agreed. Now when the assets are coming to the management of these people, the act is drafted in such object of the act is promoters are delinquent, so they should not get the management. But then for quite some time it has become a boon for the delinquent promoters to come back and take over the company. Then only section 29A was introduced. It is not there in the original scheme of law. It has been introduced after this problem was found and disqualifying the promoters. So it is not that a legislation when is that is on an experimental basis, but sometimes the main point itself is ignored by the people who drafted the legislation at that point in time. Second thing what happens is, when the legislation is moving towards this, there will be gaps in relation to the practical ground realities. That's what IBBI has done now. Earlier regime under IBBI, Dr. M.S. Sahu, they were not recognizing the real problem that is resulting in loss. They were very bookish. But now after this gentleman Ravi Mittal has come, is exactly looking at the core problem is what I feel as of now. I don't know. But still how we can implement it, we don't know. So dear friends, in this situation he didn't address that point also, and that point being section 230. You put 30 days only, you put 5 days also, you put 300 days, but it doesn't work out. You understand, like that? Because now he thought, because I have suggested this point, maybe he considered that thing. What is this 230? Why did you introduce it unnecessarily? Instead of 330 days, you could have made 360 days. That's all, no? 330 days, why you should close it? Because you didn't have resolution plan. And within 30 days, will you get the resolution plan? No. So, best step is you extend that by 30 days instead of bringing in a new legislation. But then IBBI would have thought, since it's order of NCL 80, we could not remove it once for all unless legislature, this works under subordinate legislation. The parliament must have taken that stand. 230 is waste, uncalled for. New legislation, huge litigation. Only beneficiaries are lawyers and others. So now, for example, friends, all 230 failed because what legislation will apply? I give an example. In one case, in 230, we got into 230, and in that 230 scheme when we started, the original order of Honorable NCLT took the liquidation value of the company. Both values they have put it in the order. That means the liquidation value that was done is already known to everybody. Now if you see regulation 35 CARP regulations are there. If you read that, one of the points that says is the valuer, registered valuer and the insolvency professional shall keep the value confidential, shall keep the value, fair value and liquidation value confidential. Average method you will take. Now the next point starts is, you are going to prepare an information memorandum. You have to give the list of the assets. List of the assets have to be given, and then the fair value also will be known, and the fair value also will have to be known to them. Then only they can do something about financial due diligence they can make. So that is what that was defined. What is fair value and liquidation value? Regulation 35 was talks about it. So in that they have said it should be kept confidential. That's all. That is applicable only to that place, because a liquidation value is known to the resolution applicant, then his way of approaching bargaining will be different. Therefore it should be kept confidential. Fair value, yes, everybody should know, otherwise what is that bank and how the bank is for the purpose, the value is for the banks. Information memorandum, you are going to give the assets. All right. But if you come to this section 35, This is in liquidation. Now in between is there is to section 230. So what happened? We had a problem. Everybody 230 we have to finish fast in 90 days. And everybody knows the liquidation value and fair value. And it was about 20 months before done. COVID was there. So the net result is everybody said no, liquidation value is 10 rupees. It is there, you can see. After this it will not be even 5 rupees. We are giving 6 rupees like that. So then that was what we have done is we have taken opinion, and in the opinion we have read this 35. You see the practical exigencies are there where the persons are quoting very low price which will be better than less than the liquidation value. So the essence of that you need to know the liquidation value. The next question is what is that regulation 35 says? Regulation 35 you see here friends, it is saying that where the valuation has been conducted under regulation 35 of insolvency, these things, regulation 34 of CIR process, whenever you do, that means already valuation is done. Already valuation is done and you are trying to, the liquidator trying to take that value. So first of all in section 230 has not come. The full, there are two parts of liquidations are there. One, now because of introduction of 230 in the old scheme, now they have made it a intermediary. So 230 this doesn't apply at all, regulation. When that doesn't apply, how can you take it? That is the code, it is a code. And in one of the orders passed by the adjudicating authority, since code doesn't provide for liquidator and removal of liquidator, we are going to General Clauses Act. In code, if it is there, it is there. If it is not there, it is not there. You cannot go to General Clauses Act 16. Nevertheless, in code itself is there, regulation 3. Now they have said that regulation 3, which eligibility criteria is laid down. So the scheme of things, the jurisprudence of liquidator is that is a triangle. One side is liquidator who is coming in the place of promoters. Other side is creditors, secured creditors, claimants, and the other side is the there is a company. This is the claimants, maximum realization to the stakeholders, and then corporate debtor, which is to be revived, waiting for revival. So that is in the interest, maximum interest, because the idea is to revive. So liquidator has to be extremely independent. But then they have introduced a new provision to remove him. But one good thing they have done is record the reasons for removal, because it is not there in section 27, but it is there here. It is because the position of liquidator is different. You keep the objective of revival is still in liquidation, but then the liquidator is given full charge. And since they are becoming too powerful, it is necessary that the people who paid money should control. That is where, but to balance these two, they have introduced that reasons to be recorded one, and we will see that 31A that will come. That one regulation itself I am taking lot of time. Now we will go to this 35. So 35.1 talks about valuation done in accordance with CIRP regulations. What you should do, that was defined. But you come to a full-fledged liquidation within 7 days. Within 7 days, you will supposed to decide. This is in cases not covered under where liquidator is of the opinion that fair valuation is required circumstantial within 7 days of liquidation commencement date. Now question is, what is liquidation commencement date? You are the date on which the order is pronounced, or the date on which section 230 scheme has failed. Here it has come meaning, because what they have done is the committee of creditors decides to go in for liquidation. All right, the committee of creditors decides to go in for liquidation, and what happens is